So, good evening, everyone, if you're here in the Southern Hemisphere, and good morning if you're in the Northern Hemisphere. So, welcome to the next Ross Parsons Centre for Commercial, Corporate and Taxation Law Downtown Law and Business webinar series. We've been doing these about every 2 to 3 weeks this year during the pandemic. And the format of these webinar series is that we have a keynote presenter who sometimes is presenting a paper that they've written or sometimes is discussing a particular issue that's come up in their research. And then we have a practitioner commentator. And really the goal is to share some of the work that's going on, not just in Sydney Law School, because we have some presenters from outside Sydney Law School, but some of the great work that's going on throughout the universities, both in Australia and internationally. And then having the local practitioner as a commentator just makes sure that we're able to get the most out of the presentation in terms of understanding how it affects business people and legal practitioners. Now, I would encourage you to ask questions as we go through. We do have a chat button that you should be able to see on your toolbar there. We've designated about 10 to 15 minutes at the end of the presentation for us to have general Q&A from the audience. So if you do have any questions as we're going through, please do type them in. I'll be monitoring that chat room as we go through the presentation, and then we can deal with those questions at the end there. So if I can introduce our speakers for this evening. Firstly, we have Dr. John Wood, who's a lecturer in the School of Law and Social Science at the University of Central Lancashire in England. And John's recently published a paper in the prestigious Journal of Business Law in the UK, where he's looked at challenging decisions of insolvency office holders, or insolvency practitioners as we tend to call them here in Australia. And when I read John's paper, I thought this would make a really good topic, because this is something that a lot of Australian practitioners are interested in. As John knows, we've had changes to our law over the last few years that have reshaped, I mean, from my perspective, the relationship between the courts and insolvency practitioners in terms of including very broad provisions in our insolvency practice schedule and insolvency practice rules. And so I thought, even though the paper is understandably focused on UK law, there's a lot of learnings from the research that John's been doing that I think will be of interest to local practitioners here. John undertook his PhD studies on corporate rescue law at the University of Leeds, and he's been working at UCL in England since 2014. John is a fellow of the Higher Education Academy, a member of the Society of Legal Scholars in the UK. He's also an academic member of INSOL, and he's an academic member of the Insolvency Lawyers Association. Our commentator for this evening is Karen Petch. Karen is a barrister at New Chambers here in Sydney, and she's got a broad commercial practice with specialised experience in insolvency and corporate law matters, including both domestic and cross-border insolvency, corporate finance, derivatives, structured finance, schemes of arrangement, and shareholder disputes. Prior to coming to the bar, Karen was a solicitor at A&O in London and also in New York. And prior to that, she worked as a tipstaff here in the New South Wales Supreme Court and also as a solicitor at Minter Ellison. Karen has a Master of Corporate Law, first class, from the University of Cambridge, and she also has a first-class honours degree in Law and Arts from the University of Technology, Sydney. So thank you both for giving up your time tonight to share with us some of your local experience and scholarly research in terms of challenging decisions of insolvency practitioners. So I'll now hand over to you, John, if you'd like to share your screen.
Absolutely. Thanks very much, Jason. I'll be with you in a second. So hopefully you can now see the slides coming up. Yeah, perfect. Okay, thanks very much, Jason. And obviously, it's wonderful to be here, if only virtually, but I do get the sense that this might be the future for conferences and academia in general. Just want to start by extending a warm welcome to everyone in the UK, Australia and beyond. It is 8 o'clock in the UK, so nice and early, but nonetheless, a good way to start the day. As Jason said, this is a paper based on one I published in the Journal of Business Law. There have been a few amendments since the publication of this article, which I'll deal with toward the end of this presentation. There is a brief mention in regards to Australia toward the end, but I know that Karen is going to be discussing those matters, so I'll keep that quite brief. So just to get started, just a bit of background information to the paper. What this is looking at is effectively looking at the role of insolvency practitioners, their decision making, and how the courts could, in some cases, intervene to potentially challenge those decisions made by the practitioners. In the UK, it pretty much originated from the Cork Report in 1982. Despite the fact it's a number of decades ago now, it's still very much seen as a starting point for a lot of academia pieces. So within this report, it very much effectively set out that the successful insolvency regime was almost entirely dependent on those who administered it. So they very much recognise that the insolvency practitioners are the key players when it comes to insolvency in the UK. The role that insolvency law plays within the commercial world is critical to the promotion of commercial predictability, which includes preventing injustices, whatever form they may take. The insolvency office holders are afforded very wide discretion in terms of how they can make their decisions. But of course, how risk can be approached and interpreted, and how these commercial realities pose themselves obviously presents some disparities in the way that that discretion is exercised. Discretion exercised on commercial grounds has often thwarted successful challenges made by creditors, since the courts have traditionally shown a reluctance, and perhaps rightfully so, to interfere with officeholder commercial decisions. Grounds for pursuing claims often involve, from a creditor's perspective, a case of maybe challenging on the grounds of perhaps the office holder has not considered the interests of that particular creditor, has selected the incorrect insolvency procedure, or in some cases has simply charged fees which may be considered excessive and not reflective of the work undertaken. Overall, sometimes creditors are left with limited options in how to pursue a challenge. Just a little bit more about commercial predictability, because I think this is very much the foundation point in why the insolvency practitioners are afforded so much discretion. While commercial law tends to be rational and responsive, with genuine attempts to accommodate and facilitate commercial practices of the business community, the courts have been mindful not to overstep its jurisdiction and amend or alter the law to suit commercial needs. Effectively, what we're saying here is predictability in the commercial world is absolutely crucial. It's important that the office holder's decisions are given the necessary legal authority to bind all concerned parties. Since commercial law consists of special rules which derive mostly from the law of contract, this will ensure the focus of commercial decisions rests on what recognition should be given to the parties in a given transaction. So the courts have made it clear in a number of cases that party autonomy is of unequivocal importance, and that they would refrain from intervening in commercial disputes unless it was for the purpose to achieve predictable legal decisions. This provides a premise that judicial intervention should be reserved for those instances where the law has been perhaps misinterpreted, or where there had been a misalignment of commercial law and commercial practices. Now, it's worth noting that party autonomy has not always been fiercely protected, with much being dependent on the parties and the area of commercial law in question. To turn into the judicial control briefly before we start having a look at the extent of the office holder discretion. It's interesting to look at judicial control from a case law approach. Now, the UK has an extensive range of cases that talk about the role of the courts, the judicial discretion in relation to office holders. And it establishes why office holders have discretion and explains to some degree the extent of that discretion as well. Often the starting point, certainly in the UK, is looking at the ex parte James case in 1874. And it's been expanded upon over the years to the point where the rule encompassed new territory. For instance, the rule had become the legal authority to demonstrate that the courts would not permit office holders to take any course of action or to take advantage of a technical position in law where it would be dishonourable. Now, the Court of Appeal case had dismissed a stricter test, and I'll be looking at that case toward the end of this presentation. It was a case that was considered after the publication of the article, so we'll be looking at that briefly in terms of the impact that the layman Australian case has had an impact on this particular case. But certainly look at the cases, certainly with the Deloitte case, the court's inherent jurisdiction to control the conduct of its own officers was beyond dispute, and I think that's effectively been a key point that's moved forward as well. And it's certainly something that you see in a number of insolvency amendments that have taken place in recent years as well. The sticky point, though, is the stricter unconscionability test. As I say, I discussed that toward the end of the presentation, but there seems to be an issue in terms of how that test is going to be applied. So the approach taken by the court does not always ensure a consistent and orderly conduct of business affairs, as I'd say with the cases I'm going to be looking at toward the end of this presentation. Now, in the insolvency context, while the courts have remained reluctant to state that parties to a commercial contract occupy a fiduciary relationship, the courts have been inclined to enforce fiduciary obligations if the parties had intended for such obligations to arise. Both administrators and liquidators can be in a fiduciary position, and it's worth noting as well, the courts have jurisdiction to intervene and investigate whether the office holder's conduct has contravened equitable principles. So this seems to be a possible way around not necessarily dealing with the decision making of the office holder, but perhaps their conduct instead. For example, the liquidator would be in a fiduciary position in relation to the company and must act honestly and exercise their powers bona fide for the purpose for which they were conferred, and not for any private or collateral purpose. To act honestly would infer that the office holder acted equitably, and in turn which is interchangeable with terms such as good faith, honourably, by fair means, and with clean hands, which effectively all those terms are very much of equitable nature. Now, good faith does cause problems because it's not a term that necessarily has been defined, but as far as I'm aware, the closest definition to good faith is to not act in bad faith. So it's effectively just putting some kind of a measurement in terms of it should always act in the best interests. Now, good faith in this context would imply that the actions of the office holder were sincere, but this would not necessarily mean that the decisions taken were without potential issues. But note that the concerns of creating rigid approaches to commercial law would cause mischief. So again, whilst it's important to highlight the importance of predictability in commercial decisions, it needs some flexibility to operate in practice. So it's kind of a middle ground in terms of trying to do the best for commercial decisions. Taking the judicial control a little bit further with a number of further cases, since the Clark case, it was seen that unfairness as a substantive legal concept has now become well embedded in the law. There's certainly been a number of Lehman Brothers international cases, and in particular the European case in 2015. Now, the court considered that it would likely only apply to circumstances where an honest man would disclaim any such right or consider it dishonourable to assert it, but there is a gap in the law and the law itself provides no recourse against its assertion. The obvious examples being mistake of law and receipts from third parties. Now, the strict interpretation means that it's likely that office holders may consider that their conduct is now less at risk of a challenge. And it's also plausible that those that are dissatisfied by a decision or the conduct of the office holders may be less willing to challenge such decisions based on this ruling, especially where the office holder relies on contractual rights and obligations freely entered into, and the law of contract does not allow the contract to be reformed or rectified or otherwise invalidated. So in particular, these type of cases, the focus seems to be between the unfairness test applied in the Lehman Brothers Europe, which in the European case, it was considered to be inappropriate because there was concern that it had become an unruly horse, which should not be followed. Nonetheless, as we'll see toward the end of the presentation, that seems to have been changed, which could have obviously major implications in terms of what the real test is. Now, based on these rulings, the willingness to challenge could be majorly interfered with. Now, the first expectation of what is expected of the office holder and the extent to their discretion is due diligence. Now, in order to appreciate the use of discretion in an insolvency context, it's crucial to appreciate that the decisions are made within a commercial environment. They are often difficult decisions based on commercial realities and are likely to attract criticism from those who lose out. With any insolvency situation, there are always going to be winners and losers. That said, it has been accepted that hindsight is a wonderful thing, and it's easy to criticize office holders' decisions regarding the decisions made. Ultimately, decisions that are reviewed have to be reviewed in light of the information that was available at the time and what access to information they had. To second-guess decisions would be undesirable, since it would encourage applicants to challenge an office holder on such grounds, and there would be a risk that the courts would be flooded with applicants of this sort. It is clear that the courts are reluctant to second-guess commercial decisions made by the office holder, despite the possibility that a better alternative existed. So again, it goes back to the point that there may be a number of options available to the office holder to take in terms of a decision. But ultimately, the discretion is afforded to the office holder to make that, and as long as it's justifiable on commercial grounds, it may not necessarily be the best option that could have been available, but as long as the option that was taken was justifiable at the time, then it would be very difficult based on due diligence to challenge that decision. So instead, the focus would be on how the discretion was exercised by the office holder, with attention drawn to the presence again of good faith after taking proper advice. And it seems to be the case, looking at a number of cases, in particular AMP Music Box Enterprises in 2002, that if advice has been taken in good faith and a decision has been based on that advice, then it would be extremely difficult for that decision to be challenged. The lack of good faith could potentially cause some issues. Judicial intervention would take into account the overall disruption that this would cause to the insolvency process, taking into account the consequences of that intervention on encouraging other applicants to file challenges with the court, even if some of the cases did have merit. Ultimately, what the courts are concerned with is they do not want to open the floodgates for potential measures which perhaps they did have some merit in terms of there was something there, but overall, they will look at the consequences of maybe making an amendment to the discretion exercised by the insolvency office holder. They're trying to get a balance between allowing commercial practices to unfold on a predictable basis, whilst at the same time allowing the office holder to do their job. After due diligence, the second point that's worth considering is fair and reasonable. Now, the test in Telewest communications is not absolute, since the test indicated that the scheme within that particular case need not to be the only fair scheme, or even, in the court's view, the best scheme available. It was clear that the courts would be slow to differ from the arguments put forward in the creditor meetings by the majority if this subsequently put some creditors in a bad position. In this particular case, it was considered that the best people or best group to be the judge of the decisions were the creditors themselves. There has been some developments in the UK, in particular the Small Business Enterprise and Employment Act 2015. This particular act provided for significant change in how decisions of creditors would be taken in all insolvency proceedings. The change removed the need for formal and often costly creditors' meetings with a process of deemed consent. The deemed consent certainly been an interesting development, partially in response to, again, a reality that a lot of creditors don't often engage with the process, and this is trying to make the office holder's position easier. Whether this benefit outweighs the concerns that certain creditors are being perhaps not informed of the decisions remains to be seen. While the lessons of the regulatory burden on office holders, such initiatives also acknowledge that there are difficulties in the industry with creditor engagement, and it's hoped that the greater use of e-communication and online platforms will make the process more accessible. Given the developments with COVID and issues with forming large groups, it's probably going to be elements of e-communication that's going to be used more often. So it'd be interesting to see how the pandemic will impact decision-making and creditor meetings in the future. I'll just certainly put that as a side note because I think it really would be interesting to see what impact that would have. The third expectation concerns the autonomy of the office holder and the importance attached to these commercial decisions. Now, office holders should exercise their own judgment rather than rely on the approval or endorsement of the courts to their proposed course of action. There have been a number of instances where the office holders have tried to use the court to tell them what to do to some regards, maybe seeking or wanting to seek directions from the court on certain matters, potentially trying to provide some support for the decision they make and maybe even protect themselves from litigation further down the line. The T&D Industries case in 2000 was certainly an interesting one, where the court did make it clear that they were not there to act as some form of bomb shelter against action taken towards the office holders. The courts would, however, intervene if there had been a wrong appreciation of the law, since this requires little discretion from the courts as to what amounts to unfair or unreasonable treatment to a creditor. The reason why the court would intervene on wrong appreciation of law is quite simple. It would be a rather objective test and something that the court is familiar with anyway. So interpreting the law is not necessarily beyond what the court often involves itself with. What it will distance itself from is second guessing or questioning commercial decisions, something which the court recognises it's not necessarily in the best position to do so, and often makes reference to the fact that office holders are trained and certainly have more experience in dealing with such matters. This has actually become much of a focal point for challenges in office holder decisions as well. However, it is important to note that the law requires a speedy and often expedient decision-making process, and office holder decisions should be assessed in that context. Therefore, hindsight judgment that takes into account unknown information at the time the decision was made should be avoided. It goes back to the points that I've made before, that they have to base decisions based on the information they have. So if it turns out to be potentially a wrong decision or a decision that wasn't the best, then that would not be enough to allow the challenge to go forward. Just one more point before we start looking at the grounds for challenging the office holder decisions. I always kind of think it's important to make sure there's some reference to public interest. I appreciate it doesn't often go down particularly well sometimes talking about, well, what public interest should be involved with commercial matters. Well, the courts have shown reluctance to assign much weight to the public interest, there's no doubt about that, but they have not been entirely dismissed. So the reluctance is often associated with commercial nature of insolvency and party autonomy, as discussed in the previous slides. However, it's important that the courts, when considering the interests of creditors, even if marginally, that they do not dismiss the public interest arguments too readily, especially if there was a danger that by doing so the courts run the risk of openly approving and thereby creating a precedent for office holder conduct that harms the applicant's interests. So overall, it's not necessarily a major factor in the court's decision making. However, it can be considered marginal, and I think if it is at least marginal, it's something that needs to be given at least a little bit of weight, especially on those cases that may concern creditors. So moving on to the main part, then we're just having a look at the grounds for challenging office holder decisions. There's a number of different ways that this can be done, certainly in the UK. So it was noted in a previous slide that the office holders have wide discretion to make decisions as they see fit. But it is imperative that commercial decisions are still based on reasonable, justifiable grounds. Now, paragraph 88 of Schedule B1 of the Insolvency Act 1986 concerns sufficient cause to remove an administrator. Now, while the discretion of the courts is wide, it must be established by evidence that there is good or sufficient ground of cause for the removal of the administrator following the Finiter case. It should consider the beneficial consequences or to assess impossible legal proceedings, and it may involve considering the wishes of the majority of the creditors. But one key point to note regarding this one, it's not often used in the UK, not as much as the next challenge that we're going to be looking at in a second, but it's worth noting that the removal in itself does not imply misconduct by the administrators, a factor that may help to encourage the courts to exercise its discretion. And I think that's a very interesting point, that you can remove administrator, but no blame or no misconduct is often attached to that. I admit it's a very strange ground, but I think it's just trying to maybe keep the integrity of the profession and make sure that the courts don't often involve themselves too much in the reasons why. The main area, though, is looking at paragraph 74 of Schedule B1 of the Insolvency Act 1986. So the second ground is quite broad indeed, and it's a very important paragraph to bear in mind, and it's something I'm going to be looking at with the last case at the end. And it concerns the conduct that unfairly harmed the interests of the applicant. We're going to be looking at harm on the next slide in more detail. This is read in line with the well-established principles of the just and equitable winding up petitions contained under section 1221G of the Insolvency Act 1986, along with unfair prejudice petitions, as the applicant must initially discharge the burden of establishing a tangible interest. So what is this paragraph concerned with? Well, It looks at the presence of harm, and in particular, when we're looking at harm in the context of paragraph 74, unfair harm would ordinarily mean unequal or differential treatment to the disadvantage of the applicant or applicant class, which could not be justified by reference to the interests of the creditor as a whole or on the premise to achieve the objective of the administration. Now, it could also apply to situations where the conduct was unfair to everybody in a designated class. Should a swift approach not be achieved, the administrator could also face a challenge from an applicant if it could be shown that the administrator's approach had led to the applicant's interests being unfairly harmed following the Lomas case. To satisfy the test, the applicant would have to demonstrate that there was a causal link between the action of the administrator in question and the harm to the applicant's interests. However, to establish the necessary link would be difficult, as conclusive evidence would be required to convince the courts that the threshold had been met for it to exercise its discretion. For example, if the ground for challenge suggested that the applicant's interests were unfairly harmed because the administrator did not devote enough time and resources to answer creditor questions, then this could be easily be dismissed by administrators if they could demonstrate that they had acted in accordance with their obligations under Schedule B1, which deals with the rescue potentially of the company. So I think harm is generally should not be seen as a magic wand that you can see in the Lehman Brothers Australian case at the bottom to sanction office holders' actions. And the threshold of harm has been considered in a 2020 case, which is at the end of this presentation, which I'll talk about then. So just bear in mind, I'll return back to harm in a second. The third way in which it can be a challenge is aggrieved status in liquidation. Now, I don't propose to talk too much about this, but simply just noting that it is the third ground for challenge under section 168, subsection 5 of the Insolvency Act 1986, and to assess what would amount to unreasonable or absurd behaviour required the court to consider the fiduciary and other duties of the liquidators. Now, as long as the liquidator had exercised their discretion bona fide and not fraudulently, then the courts would unlikely intervene following the Lyon case. Now, interference by the court requires something so utterly unreasonable and absurd that there's no reasonable liquidator would have so acted. And it's interesting to note that this approach has also been followed in the Stanford and Ackers case, the Court of Appeal of the Eastern Caribbean Supreme Court, with the British Virgin Island case going on to clarify that the threshold for publicity was high and could not overcome the judge's factual findings. The Court of Appeal of the Eastern Caribbean Supreme Court placed great weight on the commercial decisions by the office holders, and that it was within the office holder discretion to make such decisions, so there was no basis to challenge this position. So it certainly seems, following the aggrieved status in liquidation, that it would have to be something quite unreasonable and absurd for a successful challenge to occur. So just moving on to the last couple of slides. I said at the beginning, I'll just touch upon Australia briefly, because I recognise that Karen may be talking about this in much more detail and probably more knowledgeable on the Australian perspective as well. An interesting point is just the Insolvency Law Reform Act 2016. I believe there's an area whereby you can look at reviewing liquidators, and it permits an independent registered liquidator to carry out a review into a matter that relates to the external administration of a company. On first impression, the scope appears to be quite restricted, since matters that can form part of the review include an assessment into the remuneration, costs or expenses claimed and whether the amounts were properly incurred. However, to assess these issues, I thought, which was quite an interesting point, and it'd be interesting to hear from either Jason or Karen on this point. In order to actually assess these issues, the review and liquidator would have little choice but to examine the conduct of the office holder in general. So even though it's quite narrow in terms of perhaps what you can actually examine, in order to actually fully appreciate how that decision's been made or whether it has been reasonable, you need to look at the conduct of the office holder, generally speaking. So it'd be interesting to hear whether or not that is as extensive as it may appear. In order to avoid hindsight judgment, the review must be based on whether the reviewer would have made the same or a similar decision. And this is similar in some respects to the UK, which refers to terms such as good faith and reasonableness. So that brings me to the last slide, which was a case that was published a case that occurred, just after the publication of the article, and it was interesting to see how the Court of Appeal have had a look at the issue of unfairness. So the Court of Appeal disagreed and reversed the first instant decision. There seemed to be nothing in the ex parte James to suggest that the test was one of unconscionability. Rather, the correct approach is whether the conduct had been unfair. The courts were very familiar with applying the objective standard of fairness, and so the comment that such tests would become an unruly horse did not have merit. So I was quite happy when the publication of this case occurred that I didn't go down too far down the wrong road in the article itself. So in this particular case, the courts should consider the merits of each individual case when applying the standard of the right thinking person. And similarly, the Court of Appeal held that the test of unfairness applied to paragraph 74, which the article focused upon. So that was quite a lucky break with that. It follows that the court should not permit an office holder to act in a way which it clearly would not do itself. The Court of Appeal also made it clear that the standard of a court officer is one that is even more straightforward and honest than an ordinary person in the affairs of everyday life. It'd be interesting to see how that actually is viewed and interpreted in future cases. Now, there seems to be some criticism, which are my final comments on this. The decision seems to cause some issues here for what it may appears to be lowering the bar, given that acting in an unconscionable manner carries an inference of oppression, which is a much higher bar. So as a consequence, the unfairness tests could give rise to an increase in claims from creditors who feel that they have been unfairly treated. While such criticism may have some merits, the test of unfairness will be applied to the particular merits of each individual case. So it would be interesting to see going forward whether the Court of Appeal case has actually achieved a lower bar in terms of what needs to be met for unfair conduct. And that brings me to the end of the presentation. So I'll just stop sharing, Jason. I'll bring it back to you.
Sure thing. Thanks so much, John.
No problem.
So Karen, would you like to share your experience in terms of advising insolvency practitioners here in Australia, or perhaps advising interested parties who want to challenge insolvency practitioners? What's your local practitioner's take on the presentation?
Yeah, sure. I mean, just to respond to a couple of things that John said there, I mean, the tests are substantially similar in Australia in terms of when a court will interfere with commercial decisions of an insolvency practitioner. And the short answer to that is rarely. And the reason for that is that the courts take the view that where an insolvency practitioner is exercising their powers in good faith, that they are the best person to exercise those powers, and they will intervene rarely. And of course, as John touched on, in Australia, we have the similar mechanism that if the insolvency practitioner is concerned about whether something that they are doing is justifiable, then they can apply to the court for directions in respect of that decision, and when acting upon those directions are protected. And that is very common in Australia for insolvency practitioners practitioners to apply for directions in that way. And I think something that John touched on a few times there was the concept of justifiable. And that really goes to the heart of a lot of directions applications, is they ask the court, is it justifiable that I do this? And the courts have pushed back a little bit on insolvency practitioners and say to them, you should make your own decisions, and you should have comfort that when you exercise your commercial decisions in good faith and for proper purposes, then they will not be interfered with. And I'll come to a case briefly at the end that illustrates that. But when my clients come to me, either as an insolvency practitioner or as a creditor, the question is essentially the same. Does the insolvency practitioner have the power to do this? So power is always the starting point. And the Act has different provisions. So in liquidations, I think for the purposes of commercial decisions, the relevant section is 477, and that entitles liquidators to carry on business of the company in a way that will be beneficial in the winding up. It entitles them to bring and defend legal proceedings, and they have quite a wide discretion in the way that they commence and carry on those proceedings. It entitles liquidators to sell and dispose of property, and the great catch-all, do all other things necessary. So again, all of that is informed by the liquidator's duties. They're a fiduciary, they have to act in the best interest of creditors, they have to act in a way that is in good faith, but provided they are acting in accordance with their duties in exercising their powers, they ought to feel pretty comfortable. The 477 powers are subject to two important carve-outs. One is a restriction on compromising debt, and that is particularly relevant when liquidators are litigating. If they are compromising a claim, the courts have said that in circumstances where they're doing that on advice of counsel and in good faith, they're generally protected. So that's good news, at least in some respects for some people. And the other carve out is a restriction on long-term funding. And there's been a lot of interest in Australia about that, particularly with the advent of litigation funding, the way in which creditors can fund litigation and the way in which that might skew the way that litigation pans out. So those are two important carve-outs to the powers, but the takeaway is that for liquidators, powers are pretty broad. And the same goes for administrators. So 437A deals with administrators' powers. It entitles the administrator to control business, property and affairs of the company, to carry on the business, and to dispose all or part of the business. And again, you know, not to keep restating the same point, but the courts are reluctant to interfere in that. Even if the decision has a legal element, the court will be reluctant to interfere. And I think that the sort of one of the seminal statements comes from a case in the High Court in 1988, Patrick Stevedores and Maritime Union of Australia, where the High Court, majority of the High Court there said administrators are not to be deprived of their discretion. They must obey the general law in exercising it, but their discretion is not subject to court approval. So, having spoken generally about how broad the powers are and the entitlement to exercise the discretion, if you're a creditor, as my clients are, frustrated with the liquidation, what do you do? So in 2017, some of you may remember who had to practice in that period between several different pieces of legislation and updated commentaries and additions, which no doubt, you know, kept all of our insurers happy at that time. The purpose of law reform at that time, in part, was to bring the supervision provisions together, particularly for liquidators and administrators, also to deal with disciplinary parts of the external administration process. So I won't go too far into that, but there were a series of changes in relation to discipline and oversight of insolvency practitioners. And shocking as that may be, not all insolvency practitioners are at the top of the market, and there have been some examples in the past of poor behaviour, and that prompted that series of reforms. So it's Schedule 2 of the Corporations Act, the Insolvency Practice Schedule, and it's Rule 90.15 of that schedule that now contains the power brings together a series of ways in which people used to approach the court, but brings it all into one part, entitles the court to make orders in the external administration, and makes those orders broadly. The court can make those orders on its own motion. It can make it on application of a certain person. Those people are generally people with concerns, financial concerns in the external administration, including creditors. ASIC is also a person that can make an application for orders under that section. And Rule 9015 sets out, in fact, in subsection 3, the examples of orders that can be made. And the first and broadest is any question arising in the external administration. You can't get broader than that. So to the extent that one were to challenge a decision of a liquidator or an administrator, an IP, that one was so bold as to assume that a liquidator had done something with absence of good faith or impropriety. This would be the provision to apply under. And subsection 4 sets out the matters that the court can take into account. They include whether the insolvency practitioner has faithfully performed their duties, whether they failed to comply with the Corporations Act, the regulations, or a court order, whether the company or any other person has suffered or is likely to suffer loss as a consequence of the decision, and the seriousness of any contravention. Again, coming back to the sort of topic of this seminar, commercial decisions, for the liquidators to be found to have acted for want of good faith, there would really have to be something that verges on collusion. It is an incredibly high bar, so that they would have had to have sold company assets for their own personal profit to another, to a related party. Perhaps they swore false evidence in the proceedings that related to the approval of that transaction to the extent that's applicable. We're talking about that kind of level of action really to engage these provisions. And an interesting example comes from a recent case in the Virgin administration. There are many decisions in that administration, as you might expect. But one interesting challenge earlier this year came from a fund, Broad Peak and Tor, at a time where the Virgin administrators had entered into a sale deed with Bain Capital. And for those who are not particularly familiar with the administration, Virgin Airways Australia, at the beginning of COVID, went into VA. Cash flow problems, as one might expect, being as we are an island nation and no one's allowed to leave. The administrators entered into a sale process. They invited tenders. They had a number of tendering parties. They narrowed that down to 2 front runners. They tried to negotiate a sale deed with those 2 front runners. One fell out, and they were left with Bain Capital, who proposed a solution. That sale deed was confidential, and that, I think, caused part of the concern for some creditors in the administration, because they didn't understand what was going to happen as part of the sale. But it was the administrators exercising their power under 437A entering into that deed. Broad Peak and Tor, what they wanted was to put an alternate docker before the company's creditors. And the sale deed that the Virgin administrators had entered into had to be administered in one of 2 ways. Either the sale would be implemented through a docker, or it would be implemented through contract. And the mechanism that the administrators had agreed to was that they would hold the second meeting, they would put the Bain sale as a docker proposal to the meeting, and that if that wasn't successful, they were contractually bound to adjourn the meeting at that point and then proceed with the sale consensually. Importantly, Broad Peak and Tor didn't allege an absence of good faith. They didn't attack the commerciality of the agreement, but they did raise during the proceedings some real concerns with the fact that the administrators had, as they put it, fettered their discretion, that they had bound themselves to put the sale to a docker. And there was a question for the court as to whether they were entitled to do that as administrators. The court, there are a series of decisions that I won't bore you with in Australia about how that is possibly admissible, but permissible rather. And it was Middleton, Justice Middleton in the federal court who confirmed that line of case law, and found that the administrators had exercised their powers under 437 A of the Act, that no one brought an application to set aside the sale or seek relief that it was not in the best interest of the company, and that the broad powers that the administrators had did extend to binding themselves in the way that they had. And I think what we can learn from that case, even though there was no application to set aside the sale agreement, is that Broadpeak and Tor was prepared to attack the administrators' exercise of their discretion, prepared to attack the fact that they had bound themselves to proceed in a certain way, but still did not think that they would be successful in having the sale set aside for want of good faith or the basis for setting aside commercial decisions by insolvency practitioners. So I think, again, that gives you an indication of how high the bar is. As one final remark, I will touch on something that John said about appointment of reviewing liquidators. That was brought in as part of, and is now part of the regime. It relates to the extent that the court can appoint a reviewing liquidator. It relates to conduct and remuneration, and for the reasons we've discussed, probably wouldn't feature in this landscape, this commercial landscape that we're talking about. And there are also other ways in which a reviewing liquidator may be appointed, mainly relating to do with remuneration. But that is important to understand, that there are, as a consequence of these changes, more oversight provisions, and a lot of them do have to do with remuneration.
And we've also seen special purpose liquidators appointed in limited circumstances. I'm thinking about the Network 10 administration a few years ago, where special purpose administrators were appointed purely to focus on particular transactions that had been entered into and to report specifically about that because of community concerns about the independence of the administrator. So it was kind of, you're not reporting directly on the conduct of the administrator, but the administrator before administration was in place, and you're then advising on, the status of those transactions and whether they might be set aside. Thanks so much, Karen. I've got a couple of points that I just wanted to pick up on some things that John was talking about. The reviewing liquidator, I think, is kind of interesting. I don't hear a lot of reviewing liquidator appointments around town. I wonder if part of the problem is that basically you've got to fund it. So if you're a creditor who wants to challenge the remuneration, if you're going to appoint a reviewing liquidator, you've got to pay for them. And, how long is that going to take? We probably see more applications to try and have the remuneration itself reviewed by the court rather than appointing a reviewing liquidator to review the remuneration. In terms of reviewing the conduct, as Karen mentioned, Section 90-15 in the Insolvency Practice Schedule is incredibly broad. Any order that the court thinks appropriate, and that certainly would cover investigations into the conduct of insolvency practitioners. That's very much the successor to previous provisions that were specifically targeted at reviewing the conduct of insolvency practitioners. So the courts certainly can use that. I must admit that when we were planning for this session, I was struggling to find a case where the commercial decisions had been successfully challenged. One case that I think, there's two cases that I think are interesting perhaps for the audience. So one is the recently concluded litigation involving Peter Max, who's an insolvency practitioner in South Australia, about his conduct of litigation and whether conducting litigation over a long period of time, spending a large amount of money, potentially chasing a very small amount of money, whether that was in breach of his duties as an insolvency practitioner. And after the facts actually occurred, I think 18 years ago, the case has been going on for a very long time. And that's recently come down in the South Australian Supreme Court to say that no, he wasn't in breach of his duties for how he conducted the litigation, even though it certainly was criticised by the court at multiple levels. But the decision before that, which was the South Australian Supreme Court Full Court in 2017, which is decision number 172, has just a wealth of discussion about the topic we've been discussing tonight, and essentially circumstances where a director of a company appoints an administrator, thinks the administrator is essentially going to do a deal for them. A deal never eventuates, and then the director is kind of bitterly challenging absolutely everything the administrator come liquidator does over many, many years in multiple courts around Australia, seemingly feeling like they've been burnt by this administrator, and pretty much alleging every potential breach by an insolvency practitioner that you can imagine, both under statute and at common law and in equity. And really where the court got to with that was that, as we've been discussing, it's really hard to challenge the decisions of insolvency practitioners. And just because as an individual creditor, you're not happy with the decisions that were made, or you feel like your interests have been adversely affected, it doesn't mean it's a breach of duty. And you've essentially got to establish a breach of duty. We also need to bear in mind that aside from going off and seeking specific orders to protect your interests, that creditors just don't have standing to challenge the decisions of the officers of the company. Neither do shareholders unless they bring a derivative suit. So when we think about insolvency practitioners as officers of the company, they're bound by statutory duties. Creditors don't have standing to enforce those duties. ASIC certainly can, our securities regulator, and the court, as we've already discussed, has very broad powers. Another case that I found that was interesting, which I wrote a short article about some time ago, is a case called THC Holdings, which was in 2016, the New South Wales Supreme Court decision number 1136, where an administrator was told very clearly that goods that were in the possession of the company that had gone into administration did not in fact belong to the company. They belonged under the terms of the contract and pursuant to the Sale of Goods Act to the customer who had already paid for them, and could he please return them? And they then refused, sold the entire business, including all the stock, which in fact was scrap metal. And one of the interesting points there was that the administrator taking over the running of the business, the court found that the sale contract that had been entered into, it was kind of a few $1 million worth of scrap metal, actually made the company that had possession of the stock the fiduciary of the customer. And that by disposing of the assets, when they'd been given evidence that in fact the company didn't own them and shouldn't dispose of them, that the administrator had caused the company to breach its fiduciary duty, and the administrator in that case was held liable as an accessory in equity to pay compensation for the loss suffered by the customer. So I thought that was kind of an interesting decision. A couple of other points that you mentioned, John. One was about the role of public interest. And I'd say where we see that coming out in Australian cases, and certainly in voluntary administration cases, isn't so much about the conduct of the administrator, but rather about any restructuring deal which is then proposed. So we have had a small number of cases where, even though the administrator has recommended that creditors accept a particular restructuring deed, sometimes it provides a fairly derisory return to creditors, 1 or 2 cents in the dollar, which is still better than no cents in the dollar, as the courts have said. But in those sort of circumstances, we have seen the court overturn what we call deeds of company arrangement, what you might call a company voluntary arrangement, on the grounds that it's actually not in the public interest, that it's being entered into perhaps to avoid the scrutiny of liquidation, to prejudice the revenue authority. So we've seen public interest come up there in terms of setting aside deeds of company arrangement. The area where I see the most challenges to the conduct of insolvency practitioners, and it just reflects my own interest in terms of debt restructuring, but is building on one of the things that Karen was talking about in terms of how the administrators comply with their statutory obligations, particularly around reporting. And the Virgin case is certainly very interesting, and we saw some similar issues with Network 10. And it's, as you mentioned in your presentation, John, we need to remember that insolvency practitioners are placed in a very difficult position where, you know, the concept of the burning platform or the melting ice cube, the longer we wait, the worse it's going to be for everyone. So they have to act quickly. And the courts generally leave it to their commercial decisions. But where we certainly are seeing some challenges is in respect of alleged defects in reporting. And I think certainly here in New South Wales, we've had some excellent decisions which are basically saying, look, we could sit here and try and come up with a perfect report that has every possible thing that creditors could be interested in, but then everyone will be worse off because it really is a melting ice cube. So the administrators have to do the best with what they have in the time that they have in these difficult circumstances. And if it ends up being a suboptimal report and maybe there's some things that weren't included, we can deal with that at the back end. We can challenge the restructuring deal at the back end. And of course, usually these things aren't actually challenged. So it seems that's where we're getting a bit of pushback is, well, I want to stop the creditors meeting going ahead, or I want to stop the vote occurring because I'm saying, well, you could have had more valuations or better valuations, or you could have had more, independent experts reports or something. And it does seem to me that the courts really are pushing back on that. The last thing I'd say, and then I think we've got one question there. The last thing I'd say, it's really interesting what you're saying, John, about the changes in approval mechanisms in insolvency processes in England, and was it the 2015, 2016 changes that essentially abolished creditor meetings or made creditor meetings very difficult. That's something that we're looking at in Australia, at least in terms of liquidation processes. There was some legislation that was introduced into the federal parliament today that's proposing a simplified liquidation procedure, which is going to basically be doing away with meetings, although our 2016 changes also heavily reduced meetings. So I think that's something we can certainly look to the experience of the UK in trying to save some costs. But then also, as you noted, I thought this was such an important point, if this judicial reluctance to interfere in commercial discretions of insolvency practitioners is, in a sense, focused on protecting creditor interests, and we need to let them get on with it. And, the creditors are there at the end of the day if they want to remove them or challenge or whatever. And yet what we know is creditors are rationally apathetic, that they've already lost money and they don't want to lose more. And so they often don't participate. That the threat of a creditor accountability is a hollow one in most insolvencies, with the exception of truly disgruntled creditors who are often related parties and the subject of potential litigation. Okay, so I was just looking, there was one question that got posted up, so I might just pose this and then we'll need to finish up. So this says, thanks so much for this. Perhaps as an endorsement and an advertisement for lawyers in this area, if the bar is so high and you've already lost money as a creditor, then what value do creditors get from legal services in this area? Well, yeah, I think really that builds on the point that I was just making there, that often the creditors aren't challenging these decisions because they don't want to throw good money after bad. And
I can add to that, Jason. I mean, it's not in any creditor's interest to have lengthy court proceedings about every liquidator's decision, because all that achieves is to chew up the little distribution that a creditor might have. And if what the creditor really wants to do is have more control in the process, then to the extent they can get a seat on the committee of inspection, that is a good way of getting in the liquidator's ear, or forming when I've acted for my insolvency practitioner clients, they are often telling me about what the creditors want. So they certainly listen and feel the pressure and want to act in the best interest of creditors, and are themselves nervous about coming under scrutiny. So the answer is, perhaps the best advice you can get from local practitioners is not to litigate, but to try and negotiate with your insolvency practitioner instead, or supervise informally their decisions.
Yeah. And, I think a lot of people here in Australia would remember the one-tell litigation that we had several years ago, and certain challenges to the special purpose liquidators' remuneration that every other month would end up in court, and, there'd be 20 different sets of lawyers for the various creditors who wanted to challenge the decision. And, a lot of those challenges were unsuccessful. And you just sitting back and looking at literally a room full of 50 or 60 lawyers wanting to challenge thousands of dollars in remuneration, thinking how much more money is being spent, perhaps with the idea of, it's not the money, it's the principle of the thing. We want to challenge this, whether we're actually going to get a benefit out of this or not. Yeah. I'm mindful of the time. I'm sorry to the two people who've just posed questions. Unfortunately, we won't have time to answer those. But thanks everyone for posting your questions. Thanks so much to John and to Karen for giving up your time. That's been a fascinating discussion. And like I said, there's lots of people in Australia who are very interested in this. John, I wasn't sure, but is your article available on your website? Is there anywhere that attendees could find your article?
Yeah, sure. I mean, it's available on Westlaw, which is an electronic database, and it's also available, if you search for it, it should come up under my under my work address. Yeah.
Sure. And attendees, if you send me an email, I can send you the citation for it if you're
Absolutely.
interested. So, as I said, this session is being recorded. We'll send a link to the recording to everyone who's registered, and it will also go up on the Sydney Law School podcast page and the Sydney Law School YouTube page. And we will also send a copy of John's slides if you're happy for the slides to be distributed, John.
Yep. That's fine.
So we'll send that to attendees. So thanks, everyone. I'll draw it to a close there. I wish everyone a good evening, and people in the Northern Hemisphere have a good day. Thanks very much.
Thank you.
Thanks, Jason.